welcome to the 277th session of Legal Empowerment Through Interaction lecture series. Till now, we have been thinking of different health issues, fitness issues, but seldom we think about mental health. Today's topic is the challenges in implementation of Mental Health Care Act 2017. And we got an eminent speaker, the most competent person, according to me, Dr. Chandrashekar. He is the professor and head of the Department of Psychiatry, ESIC Medical College, Bangalore. Though we may not look anywhere near in the age pattern, but on the lighter vein, we were classmates. That is, in the National Law School, Bangalore, we both did together a course on medical law and ethics some 2 decades ago. 2 decades ago, right? Yes. And to introduce the subject, yet another good friend who's none other than Dr. Roshan Bijilee, a good friend who has been in this field working on the different aspects, and currently the director of the Composite Regional Center for Persons with Disabilities, Kozhikode. And one known factor which I would like to share on the later vein onto this audience is that Roshan, in fact, played the role of Mammootty as a young child in Vadakan Veeraga, the classic movie. So friends, without wasting any time, let us get on with the session. We are indeed privileged with the presence of Justice Ramkumar sir and all of you wonderful participants. Over to you, Dr. Roshan Bijilee, for the introductory remarks.
I thank Sri Shyam sir, who has always shown a brotherly affection towards me, and my friend, philosopher and guide, Sri Arul Baiju sir, Honorable District Judge Kannur, for inviting me to this much acclaimed lecture series, Legal Empowerment Through Interaction, hosted by Shyam Associates. It is their 277th session in the series, as Shyam sir has just mentioned. When I was asked to give the introductory remark, I had tried to get an anticipatory bail from the organizers, saying that I am not currently a practicing psychiatrist, but the bail was not granted. So coming to the topic, challenges in the implementation of Mental Health Care Act 2017, the first thing which occurs to the mind of anyone in the field of mental health is that of the paradigm shift of a clinical medical based approach in the Mental Health Act 1987 to a rights based approach in the Mental Health Care Act 2017. In this Mental Health Care Act 2017, aspects like nominated representative, advanced directive, etc., has been discussed in detail for the first time in the Indian scenario. The role and significance of the Mental Health Review Board with a quasi-judicial authority has also been introduced in the Act. This basic shift in the perspective of mental health is in itself the advantage as well as the challenge posed by this Act. I'm not going into the details or the nitty-gritties, as Dr. Chandrashekar sir, Professor and Head of Department of Psychiatry, ESIC Medical College, Bangalore, a towering personality in the field of mental health, will be dealing with all these aspects in detail in his topic presentation today. Dr. Chandrashekaran sir, he is also the chairman of the Indian Psychiatric Society Task Force on Implementation of Mental Health Care Act 2017. He is also the secretary of the World Association of Psychosocial Rehabilitation Indian Chapter. He is also ex-member secretary, Karnataka State Mental Health Authority, ex-president, Indian Psychiatric Society, Karnataka Chapter. And his areas of interest are forensic psychiatry, de-addiction, and suicide prevention. And his major achievements include, he has drafted and notified Karnataka State Mental Health Rules 2012 and 2021, has to his credit more than 250 radio programs and 170 TV programs on the exclusive domain of mental health. And he is also leading the exclusive ambulance service for the mentally ill in the state. And he is awarded with the WHO Fellowship, Distinguished Psychiatrist Award, SS Jairam Award, and CRC Award. So we have here with us one of the best resource persons in the country to deal with the topic. And a few thoughts I would like to place to this august audience as part of the discussion are as follows. The chapter 4 regarding the nominated representative and chapter 3 regarding the advanced directive are all provisions of the Act which empowers the persons with mental illness to protect his right the way the person wishes to be cared for and treated for a mental illness. In a way, this is the beauty and strength of this Act, pitching us at par with the rights-based Act of European standards. But in a country like India, having a population of more than 138 crores, This in itself will be a challenge in the implementation aspect, because the awareness creation and equipping these persons with mental illness regarding this nominated representative and the advance directive in itself will be a major challenge in the implementation of this act. And also, there is a constitution of the Mental Health Review Board, a quasi-judicial body chaired by the Honorable District Judge or a retired district judge. So this is the chapter 11 the level of implementation of this mental health review board across the states in the country is another major concern when we think of the challenges in the implementation. For example, in Kerala, that bodies have been is in situ, but still it has not started functioning. Whereas in some other states, it has started functioning. And this is a quasi-judicial body which has the authority to intervene in each and every case. And the documentation process, the online registry, accessing this by the practicing clinical psychiatrist in each and every case. All these things requires a lot of awareness creation, not only among the persons with mental illness, their relatives, but also among the psychiatrists in general, because many a time this has not been imbibed to the fullest by the practicing psychiatrists. So it's a long way which we need to go in creating an awareness in the implementation of these things. And maybe coming to some tricky aspects, any person can complain to the mental health review board, and maybe a schizophrenic with a paranoid delusion, he can very well complain against the treatment. So this is some tricky aspect where the board has to be very careful as well. It's not a criticism per se, but just a food for thought. Similarly, the admission, the treatment, and the discharge aspects, section 86 to 98. The psychiatrist need to assess the capacity of a patient to have an independent admission in all cases. And also the documentation process per se with regard to each and every admission, taking a conventional standards of our clinical practice, maybe a government psychiatrist in a government mental health center, maybe dealing with hundreds of clients, maybe in a day in his outpatient clinic. So the documentation process has also increased drastically, but it's always a good thing. But again, that culture has to be imbibed by our practicing clinical psychiatrists as well. Then the minor admission procedure, a lot of caution has been exercised. Two psychiatrists or one psychiatrist and a mental health professional or a medical professional independent examination at the day or within a week of the admission. Previously, the order of a juvenile justice board was required, but as of now, this is that is not made mandatory in the current act. And also the discharge procedures and all. Coming to the duties of the police officers and all, that is another major area which I think is a challenge in the implementation, because the role of the police, the responsibilities and duties of the police has increased. They can directly bring a wandering person to the medical attention and then to the mental health care attention. So the police force has to be made aware of to the fullest regarding the new provisions in the act, so that they can also contribute to the fullest in the implementation of the act. Then also there is the decriminalization of the suicide attempt. It's mentioned as presumed to have severe stress. So there are some aspects in that where our honorable Ramkumar sir and all was just discussing in this prior to this starting of this program. So that section 115. And also a lot of infrastructure requirements are all being mentioned in the act, which of course requires further inputs from the appropriate governments for the implementation. So such things are there. And then another area is like the transaction of properties and all. I think it's not clearly mentioned in the Mental Health Care Act regarding the guardianship aspects. Other than the nominated representative, there is no specific mention regarding the legal guardianship. So whether it is to be done in accordance with the Rights of Persons with Disabilities Act 2016, the limited guardianship, or the National Trust Act 1999, legal guardianship, and also that is, I think, an area which needs a bit more clarity. A lot of such things are there, but I'm not going into any further detail, because as I said earlier, we have one of the best resource persons in the country to enlighten us on all these aspects to us. So over to you, sir, and thank you once again for inviting me for the program. Thank you, sir.
Thank you, Roshan, for now that the topic and the stage is set, things in perspective. Over to you, Dr. Chandrashekar.
Thank you, Dr. Padman. It was a great opportunity. Thanks for giving this opportunity, Mr. Shyam, and in fact, thanks, Dr. Roshan, for enlightening so much about the Act. In fact, I have been always addressing the medical people, and of course it's a unique opportunity to share my thoughts with the legal luminaries. So can I share my slides, sir?
Oh, yes. Oh, sure.
Sure, I just enable it. You can.
So thank you very much for this opportunity. What I would be speaking is just like whatever medical knowledge and little legal knowledge, whatever I learned during my implementation, because I almost for 1.5 decades, I was the secretary of the State Mental Authority Karnataka chapter, and I would be speaking on whatever knowledge I acquired. Of course, I may not be legally correct, and maybe I will be talking with my little of my emotions also. So, so just want to show this picture of Bedlam Hospital. I think it was a European hospital. I think it was in the 16th century. I think at that time there were no laws. So this picture I want to show here, what they are showing is they will admit a mentally ill patient to asylum, and in a semi-nude position, they will exhibit to the general public, collect penny, and in that money they were running the asylum. So from that day onwards, the laws have been progressing quite a lot. We have, because we had in the 19th century, we have MAD Act. In the early 20th century, we had Indian Lunacy Act, and then Mental Health Act 87 came, and now Mental Health Care Act 2017 has come. So following are the objectives of my presentation. So I just want to describe various provisions of this act very briefly. And in particular, I'll be trying to say what are the challenges in implementing, like appointing state mental authorities, advance directive, nominated representative, right to access care, how difficult it would be for the government to implement this provision, MHRBs, and how to run a mental health. These are following few provisions I have chosen for my presentation. So I just want to tell about this Mental Health Act 87. It actually started implementation in 1996, and it was very tardy, very slow. It was basically a policy making and advisory role. It had no power to the state mental health authorities. Actually, we did the licensing, we appointed the visitors, reviewing mental health programs, creating awareness. Those were the activities done under the previous act. And this new Mental Health Care Act 2001, which was gazetted on April 7, 2001, has much active role in implementing the act. But I just to always again want to show this picture of Irwadi. Irwadi is a dargah near Ramanathapuram district, where mentally ill were chained. In fact, it was in 2001 with this such chained mentally ill weren't alive. I think in a fire mission. Then it was registered by the Honorable Supreme Court of India as a suo motu writ petition, and that led to the implementation of the 1987 Act. In fact, the judicial activism is very much important in implementing mental health laws. So the history regarding this Mental Health Care Act 2017 was the process of drafting started in 2010, and Ministry of Health and Family Welfare, August 2013, it was introduced in Rajya Sabha. From 2013 to 2017, it was discussed at various forums before it was passed in the parliament in March of 2017. And during 7/4/2017, a gazetted notification was done, and the day this law came into existence. So of course, why this act has come into picture? So I just have a very brief thing. First one is United Nations Conventions on Persons with Disability. In fact, it happened in 2006. India was a signatory to this convention in 2007. And in fact, it was obligation on the country to align with the policies and laws with the UNCRPD 2006. So as per that, the objects and reasons of this act has come. So the main points in the statement of objects and reasons were recognizing that mentally ill are vulnerable and families bear hardships and burden. People with mental illness to be treated and environment should be made conducive, and protect and promote the rights of person with mental illness during process of treatment. And it also had the objective of integrating mental health with the primary care. So it repealed Mental Health Act 87. There are 16 chapters, 126 sections, and most importantly, this act has one full chapter on rights of persons with mental illness. There were 10 rights described in that. Newer sections, as told by Dr. Roshan, like, advanced directive, very new for concept for Indian community, nominated representative, mental illness and capacity assessment, rights of person, duties of government. Many new chapters were added when compared. In fact, entirely very different from the previous act. So, as mentioned in the act, objectives are act to provide for mental health care and services for persons with mental illness. And that means what we interpret is services means government has a major role to provide for mental health care. And then protect, promote, and fulfill the rights of such person during delivery of mental health care and services, and fair matters connected therewith are incidental thereto. So I just listed the various chapters of this Mental Health Act. It is like, first chapter is preliminary, second preliminary definition comes in the first chapter. Chapter 2 is about how to assess the capacity, which is so vital to improvise upon other provisions of the Act. Like chapter 3, Advanced Directive 4, Nominated Representative, chapter 5 is on rights of persons with mental illness, and chapter 6, duties of appropriate governments, central mental authority, state mental authority, and then finance and account, mental health establishment, and chapter 11 as Dr. Shah's mental health review boards, which is going to be a major challenge for the states to implement, and various other chapters as mentioned by Dr. Roshan. So Government of India within a year has made publications of the rules, draft rules, like, the Mental Health Care Central Mental Authority, MHRB Rules 2018, Mental Health Care State Mental Health Authority Rules 2018, Mental Health Care Rights of Persons with Mental Illness Rules 2018, and number 4, Capacity Guidance Document, how to assess the capacity of the mentally ill. It came in 2019. And recently, 2020, the first draft regulations of the mental health care was also published by Government of India. To comment upon it, the act is very progressive, right-based, and patient-centric. In fact, the 1987 Act was primarily drafted by mental health professionals. This act is basically works with person with mental illness as the center of the act, around which all other provisions revolve. So again, I just want to talk about this, why this is so important. Many doctors say why law should interfere with our treatment and all. This was the incidents in Bangalore, near Bangalore Kanapura Road, when a person started becoming very violent and started attacking the public. And to stop him, the passers threw stones at him and shifted him to Nimmans after he fell unconscious. He, however, succumbed to injuries equivalent. What I mean, the importance of this report, I want to always tell our doctors is, this law is very much required for protecting the mentally ill person. At the same time, by giving proper treatment, we can protect the public also. So I'll straight away come to State Mental Health Authority. So So every state government shall, within a period of 9 months from the date on which this act received an assent of the president by notification, established for the purposes of this act an authority to be known as state mental health authority. So this is the constitution of the authority. Whatever I am showing is the showing this the official members of the state authority. There are official principal secretary, health and family will be chairman. There will be joint secretaries of various departments like law, social welfare and finance and home departments, head of the department of psychiatry of the major government hospital in the state. And the constitution also is of non-official members, which includes one eminent psychiatrist, one mental health, Ayush mental health professional, one psychiatric social worker, and a clinical psychologist. And most importantly, the KIM, like, one mental health nurse, 2 persons who had mental illness. So in fact, this mental health authority has a good representation of the professionals, officials, mentally ill person, mental ill caregivers, and all. So what challenge we faced in implementing like this provision was that it is the finance. In fact, what I am trying to show here is that for one mental health authority, we require at least 1 crore building, office, furniture, staff, salary, transport, and other audiovisual equipment include at least 1 crore for 1 year is required. And we require at least 29 crore for establishment of mental health authorities, which has been a major challenge. In fact, Kerala state and Karnataka and Tamil Nadu have been good enough to provide a good amount of money to the state mental authority, by which a state mental authority office have been functioning. But by and large, many other states doesn't have a working mental health authority. So I'll come to the provision of advance directive. Advance directive as per section 5 is every person, whether they have been diagnosed as having mental illness or not, has right to make a written statement as advance directive. The advance directive talks about the way the person wishes to be cared for and treated for a mental illness, the way the person wishes not to be so cared for and treated for, and specifying who the nominated representative. So it's a very simple process as per the rules. On a plain paper, medical officer in charge of a psychiatric hospital is bound to follow this advance directive. Only mental health review board has the authority to overrule the advance directive. So my comments, why it is so challenging? Because I think we are almost 5 years are over and we have been practicing regularly. Till now, we have not had a single advance directive. It's a good idea, unquestionably, no doubt. Of course, it gives rights to the person with mental illness. Conceptually, practically, it's very difficult. And one of the comments made by one of my senior colleague was, death is certain. Many people may not wake it. It said only 1% of population think about a will. And severe mental illness happen only 1 to 2% of the population where they lose capacity. In fact, this, even though this provision is there, talks about a 1-page document which decides the fate. This provision will be underutilized or can be misused. So sometimes advanced, what we have seen, advanced directive can be used against the patient interest of a relative, that a patient remains untreated or not effectively, especially when people are not very literate about mental illness. This can happen. He may not be acceptable home, brush with law, and end it. So many consequences can happen because of false advance directive. So this is one challenge which we are likely to face. So then I am talking about nominated representative. So who is this nominated representative? In order of preference, person named by the person with mental illness in the advance directive, a relative if no advance directive is there, or a caregiver can be called advance directive, or a person who is appointed by district panel of mental health review board. So he should be a major, the nominated representative should consider a patient past wishes, values and background of person with mental illness. In case of minor, the legal guardian is the NR and member of the public and NGOs if temporarily for a homeless person with mental illness. And sometimes if nobody is there, we have to presume that representative of Director Department of Social Welfare will become the nominated representative. So these are the functions. In fact, we say it is a good idea. NR provides support to person in making treatment decisions, perform some duties under the act when the person is unable to carry out. In fact, the nominated representative role is restricted to treatment decisions, nothing about the property, nothing about other affairs. Probably that comes under the Disability Act, only when person with mental ill become disabled. And only comments we have is generally the consent for research should be taken by the person who is undergoing research. But here the Act gives power to the nominated representative gives consent and has right to information in the diagnosis. Probably the psychiatrist will feel very awkward to share many confidential information with the nominated representative. So in fact, this picture again, I just want to show it's a rehab center which was raided in Bangalore. In fact, many people, 130 people were in there. In fact, their own family members who had admitted. It was absolutely no facility inside and no beds, no treatment. And it was such a horrible place. In fact, so we have to look at how much power we can give to nominated representatives. So these concepts such as advance directives and nominated representatives appear to be very attractive, idealistic and aspirational, but not evidence based on Indian context considering the resources. So next, I just want to go to the chapter 5. It deals with the rights of persons with mental illness. In fact, it talks about 10 rights. I just want to focus on section 18 of the Act, which articulates that every person shall have right to access mental health care treatment from mental health services run or funded by the appropriate government. And government shall make sufficient provision as may be necessary for a range of services required. We actually just want to discuss this particular, how big challenge it is going to be. In fact, it's a fundamental right. I fully agree with, but for a state government, health department, how difficult it is. So when we look at the manpower requirement to provide good quality mental illness. So what I'm talking about 2011 census. So 130 crore is the population of India. People suffering from diagnosable psychiatric condition could be 10% or 13 crores. Number of people suffering with severe mental disorder is 0.8 or 1 crore. And number of beds currently is 60,000. What we require, as I can show it, is 6.5 lakh beds are required. And number of psychiatrists currently, now we know India is around 9,000. And we require about 1.9 lakh psychiatrists. Nurses, only 2,000 psychiatric nurses are available in the country, which requirement is again 1.3 lakhs. Social workers, again only 1,000. Clinical psychologists, again 1,000. So the manpower situation in our country is so low, for which we cannot. And generally, I would say health budget is only 1.3% of GDP. And total budget, that is, this is, I think, 2019, I think 2.3 this much crores. And mental health budget is very meager, less than 1% of total health budget. That itself we can see how well we are equipped to implement this provision of right to mental health care. So next I will go to the provision of mental health review boards, as Dr. Roshan was commenting. In fact, this has become a major challenge in most of the states, including Karnataka, Tamil Nadu. We started the process of appointing mental health review boards almost 2 years back. Still, we have not progressed. So this mental health review board, I think under section 73, it functions through district panels. The panel consists of 6 members. First is a judicial member who should be of the rank of the district judge, chief judicial magistrate, or retired of the same cadre, and representative of the deputy district collector, psychiatrist, and a medical practitioner. And out of this person with mental illness, family member, caregiver, 2. Totally, there will be 6 members in this panel. Chairman will be the judicial member. All decision by consensus as well as vote. And most importantly, it's a judicial body because the proceeding shall be deemed to be a judicial proceeding. In fact, if any appeal has to happen, it should go to High Court only, not at the district level. So this MHRB has enormous powers, at the same time very important and vital for protecting the rights of the person with mental illness as well as implementing other provisions of this act. So the functions they have is approval of admissions, involuntary admissions for the various every mental involuntary admission involving children, women, and adult male should be approved over time by this specific time by the this review board. Reviewing application for nominated representative, reviewing application challenging involuntary and supported admission, authority recommend to the state mental authority to cancel. So this is quite a powerful body. So again, I just come to the estimated cost of setting up of a functional MHRB. In fact, each MHRB requires one judicial member and at least 2 bureaucratic members like typist, steno, and a clerk, and a group D, and in fact Karnataka, we have appointed a judge is asking for more personally, and we request a vehicle and lot of stationaries, and most of this proceedings happen in camera. There is a camera studio is also required. So in fact, we estimate 1 crore, we estimated 1 crore required for 1 unit of mental health report. In fact, if we consider our country, 241 mental health review boards required, and we require 241 crores to implement or to appoint mental health review boards in whole of the country. So next, I just come to the mental health establishments. So as per the definition, any place where mentally ill stay overnight is considered as a mental health establishment. It could be a rehab center, it could be a counseling center, it should be a hospital. So the mental health establishment has to mandatorily register with the mental authority, fulfill minimum standard, which is very important, provide minimum qualified person for functioning in these hospitals, and they have to maintain record as specified in the Mental Health Act. And of course, registration has been simplified. The Act itself says applications should not be personal. It can be personal, post online, and provisional registration should be issued by the mental authority within 10 days and permanent in 45 days. And so once you register, you have to follow admissions as per the provisions of this Mental Health Act 1980. I just want to briefly comment about this. There's advance directive should be considered. Nominated representative will decide about the admission. And only MHRB can rule facilities for communication to be made available. That means every mental health establishment should have a phone, should have internet which is accessible to the patient, and should have good minimum standards for comforts, running water, pakka building, good qualified staff. That itself is a very challenging task for a person to run a mental health establishment. And so this is the various ways of admission. I just tried to simplify with a table. So here there are two types of admissions. One is a independent admission, other is a supported admission. So major under section 86 can admit himself with a request and get discharged himself. And again, a minor is nominated representative, has to give a request, and the medical officer of the hospital, and he has to inform mental health review board and get their approval, inform within 3 days, approval within 10 days, something like that. So this is for a minor admission. Again, supported admission up to 30 days. I think two people have to sign, like a psychiatrist and a mental health professional or a medical practitioner, and to inform mental health review board within 7 days if it is a male, and 3 days if it's a female. Again, same thing, up to 90 days, two psychiatrists have to independently examine the patient and give that opinion that he requires admission for his safety and well-being, something like that. Again, that has to be informed. And later, the mental health establishments have to get approval by the mental health review board. So, briefly, I've just mentioned following some of the things. Other challenges for implementation include lack of infrastructure, inadequate skilled manpower, poor mental health literacy of the population, because they are absolutely not aware about all these issues. They don't not even know that they will get mental illness. Stigma, that fear of stigma and fear of discrimination, another thing which prevents people from accessing mental health care. And of course, financial resources is something which we have been talking a lot. So to conclude my whatever brief talk I wanted to give, say, ultimately we require very fair and good planning by government for implementing all the provisions of the act. And second thing, demand for implementation by stakeholders, especially the families of persons with mental illness, and the persons with mental illness should demand for service. In fact, my experience over 2 weeks, in mostly the public interest litigations registered Honorable High Court and Supreme Court responsible for implementing various provisions, and adequate budgetary provisions should be made by the government, and awareness programs by the government and private mental health professionals should be in abundance to create awareness and make people access whatever mental health care is given by them. And I thank all the luminaries for patiently listening. Thank you very much, sir.
Thank you, Chandrashekar. One second. Mental health, never thought that this would be that complicated or having so much of issues. And thank you very much. And before we go any further, I'll just go straight to Justice Ramkumar sir for his comments.
Thank you, Mr. Shyam. A very electrifying introduction by Dr. Bijilee, as the name indicates. and an excellent overview of the statute by Dr. Chandrashekar. You are in a happy company, doctor, because by varying degrees, most of us are legally challenged on the issue of mental health. That way you are in a happy company. In fact, I don't have the Bayer Act also. In fact, it is somewhere misplaced. Excellent overview of the Act given. But I think we may require, for a person like me, may require a more elaborate articulation on the legal aspects of the provisions. Thank you, Doctor. Thank you.
Thank you. Thank you, Justice Ramkumar sir. We have Baju sir with us, who has been fully involved in this one. May I request him to offer his comments? Please unmute.
Thank you, Shyam. The initial starting time of the meeting, I was not there, so I could not hear Dr. Roshan Bijilee. Actually, we face
There's some connectivity problem in Mr. Baiju.
dealing with the properties of the mentally ill person.
It's not audibility. It's a
Connectivity
voice.
problem, I believe.
Yes, voice is breaking.
Shyam, please go to the next person. I will try to.
Yes, I think the person who gave the introductory address itself, Dr. Roshan Bijilee, if you can just offer your comments on what Dr. Chandrashekar just described or elaborated.
Yeah, sir, thank you, sir. Chandrashekar sir has very rightly summarized the crux of it. Like the greatness of the act has really been reflected. At the same time, the practicality in its implementation in a country like ours. It's, as I said, it's at par with any European standards for an act, like very much right-based. But when it comes to an Indian scenario, to what extent, he was rightly pointing out the concerns regarding the implementation of the MHRB, that review board, their roles and responsibilities. So such things, and what Baiju sir was just now telling regarding that some gray area related to the guardianship related issue. So such things, then that advance directive as well as the nominated representative, to what extent, again, in a country like India, where there is such a range of people at one end, illiterate, poor population, to the other end of the spectrum where we have. So there's a wide spectrum. So to implement or to get this great act to be implemented to the fullest would be the greatest challenge, which I feel, sir.
Thank you.
Finance is the problem everywhere. Finance. Even in the judiciary.
Baiju sir, your connectivity issue, I think, might be
Rectified.
I'm not sure. It is rectified.
Okay.
I think in the meantime,
Hear me?
No, not yet.
not yet. I think we'll give some more time for the connectivity issue.
Still the problem is there.
In the meanwhile, I'll request Advocate B. Ramkumar Nambias, your comments.
So thank you very much. Can you hear me?
Yes.
No, thank you very much for the very wonderful speech. But a couple of issues, legal issues, as Justice Ramkumar sir rightly pointed out. We spoke about the composition of review boards, and we know what the functions of the review board are. Now, what irks me is the composition of the board itself. The board, the section 74 speaks about the composition of the board. One is a district, two is a representative of the district collector, C, two members of whom one shall be a psychiatrist and the other shall be a medical practitioner. Now, the fourth one, that is D, 74D, is what troubles me a little bit. That is, two members who shall be persons with mental illness or caregivers or persons representing the organizations of persons with mental illness or caregivers or non-governmental organizations working in the field of mental health. Now, does the act mean that two persons who shall be persons with mental illness should be part of the review board which decides on certain things? Is that legally correct? Ramkumar sir, I have my own.
This is a very valid doubt because persons with mental illness, are they capable of taking decisions?
I say that is because with regard to central mental authority under section 34 and state mental health authority under section 46 speaks about a slightly different version. Central authority, central mental health authority speaks about, that is section 34 M, says two persons representing persons who have or have had mental illness to be nominated by the central government as members. Two persons representing persons who have or have had. Now they are representing them. Now the same wording is there in section 46 of the state mental of the state authority also. As far as the review board is concerned, which is having wider powers, they should have two mentally ill persons. Now I don't
Maybe
understand.
maybe they may take decision during lucid intervals.
No, sir. This was discussed during discussions of this drafting the law.
Yes.
In fact, many were against implementing, having these people, but the group of mentally ill who proved that many of them have capacity to take decisions. Only when they lose capacity, they are unfit to be part of this mental health review board or the authority. As long as they have mental illness, doesn't mean that they have a loss of capacity. They can take part in all decision making. That was the argument given by the Association of the Mentally Ill in the stakeholders meeting which happened while drafting this law, sir. Ultimately, they were included in all this board as well as.
And probably to the treatment given out to the other mentally ill persons also, to empathize with
Yes,
them.
sir.
Understand.
They're telling us nothing, no decision should be taken in the act without us as a part of the stakeholder. They consider themselves as the most important stakeholder for implementation.
I think that is a legal issue which will have to be decided one way or the other.
Yes. But anyway, their verdicts may not be decisive.
Yeah.
They are only.
So another aspect is the decisions from the review board is appealable to the High Court. We'll have to sit here and decide.
Then again, let us not confuse mental illness with insanity and things like that, because mental illness can be very many different things. So it has got different shades of grey.
Sir, chapter 2(5) says that the determination of a person's mental illness shall alone not imply or be taken to mean that the person is of unsound mind, unless he has been declared as such by a competent court.
Correct.
Yes, sir. I fully agree. Insanity is different from mental illness.
Correct.
Yes. And for Section 84 of the Indian Penal Code to be applied, it should be legal insanity, not medical insanity.
Yes, sir. Yes, sir. Yes, sir.
McNaughton's rules have to be applied.
Yes, sir. Yes, sir. Yes, sir.
Let's hope. Hari Kumar, sir, you want to add something? Please unmute.
My real query in mind has now been almost cleared by Justice V. Ramkumar, sir, because I was also thinking in the very same lines, what would be the impact of Section 5 read with Section 84 of the IPC? Suppose a real crook wants to do something after pretending that he is mentally ill and getting himself admitted to a hospital. Then he makes some scribbling under Section 5. And thereafter, he gets himself out from the hospital and does something. Can he not take the protection under 84? This was really alerting me also after hearing the erudite presentation made by Dr. Chandrashekar.
Thank you. Thank you, sir.
Right. There is a joke that a lawyer advised his client to pretend that he is unsound and he is mentally ill person. He pretended so, and ultimately he was acquitted. And lastly, the lawyer asked for the fees. Then also he pretended to be lunatic.
Baiju sir, your connectivity issue is over? Not yet.
Shyam, is it over now?
Oh, yeah,
I'm not
please,
sure.
You can.
I'm not sure.
Yeah, please.
My connectivity issue is over, according to you.
No,
I mean, let us not strain it much. Get directly to the point, please.
There's slight cracking of voice.
So, actually, I wanted to write an advance directive. I just wanted to write and register an advance directive. I contacted Sri Shankaran Nair. Sorry, sir. The connectivity problem is not
Still
over,
there.
I think.
Still there.
No issues, no issues. Please go ahead. We can hear you.
There is some. What I'm saying that actually wanted to write and register an advance directive. I wanted to be the first person in Kannur district who is going to write an advance directive. I contacted Shankaran Nair sir for that purpose. He said that there is no infrastructure for me to have an advance directive.
Practical
Problem
difficulties.
is still there. So, yeah. Practical difficulties in writing an advance directive also is there.
Yes.
Dr. Chandrashekar, how far advanced directives in Karnataka state? Is it in vogue or it is just in the pipeline?
No, sir. Now this the regulation 2020 has given clear guidelines about how to make an advance directive. It should be first written on a piece of paper, and capacity should be certified by a medical practitioner, and it should be registered with the mental health review board. That is what but till now I don't have any news about that provision being used by any person in Karnataka states. We have a functioning MHRP. We are function. Of course, lot of admissions do happen. Thousands admissions do happen in Karnataka. Not even a one with a advanced directive.
Dr. Chandrashekar, we have a question from Dr. Deepaksha Mandal. Can you, doctor, please unmute and put your question? It is there in the chat box, but if you can unmute and put the question, it will be beautiful. Deepshikta Mandal. Yeah, please, doctor.
Hello, good
Yes.
evening, everyone. Hi, sir. Actually, my question is.
Yes, madam.
My question is actually, Dr. Chandrashekar. Actually, what happens if someone with mental illness does not have any nominated representative?
Madam, most of the, in fact, 99% of the admissions in our state or even many mental hospitals is happening without the presence of a nominated representative. Majority of them admitted as an independent patient after taking consent. And other places we presume that his relative is the nominated representative, and we take the patient consent and request from the patient relative. As such, this provision is not yet used, madam, as per my knowledge.
Okay.
Doctor, are there families who want to really get rid of such persons and get them admitted in mental health centers so that they will not be a problem to the other members? There may be unmarried girls to be given in marriage. So they want this troublemaker to be kept in the asylum, or rather in the mental health hospital. Are there real families
Yes,
there?
sir. Yes, sir, plenty, sir. We have something like 200 registered mental health establishment in the Karnataka state. Some of them, they promote that we keep them lifelong, we are long stay home. In fact, many families do dump them.
Correct.
Of course, they are using all these provisions like involuntary admission and all those things, but practically they are not yet literate to use the Section 90 of this Mental Health Care Act. All those things are not happening, but many people are kept in mental asylums for years together. We have seen some people kept in a private establishment for 10 years, and Nimmans almost 20-25 years. And in the Harvard Mental Hospital also, many people stay for quite long times. That's happening.
Okay.
Sir, we have Sumesh Kalarikal who has submitted advanced directive. Please share your experience.
Yes.
A very good evening to all, sir. I have a family issue in my home around 10 years back, and one fine morning, all of them tried to make me a mentally ill person. So I filed an advance directive in Kerala around 1 year back. And unfortunately, the review boards in Kerala are still not working to the best of my information. And I am from Idukki district. and there is a review board is already been established in Kottayam. And to the best of my knowledge, it is not working so far. Functioning is not yet started. Maybe due to the allocation of money and all other things.
Sir, in that case, only that document has to be brought to the attention of the medical officer in charge of wherever you want to take treatment, because the Act clearly says the medical officer is bound to follow advance directive.
Yes,
Registration is not mandatory.
but my case is that, excuse me, sir, but my case is that I am not mentally ill.
No, sir, when you become mentally ill, you are somebody who we have told, who you have informed in the thing. He can bring the document to that person. There is
Yes,
no need
sure.
that when you are ill, you can give consent and manage everything. When you are not.
Yes. Okay, thank you, sir.
Thank you, Sumesh. All the best for your advanced direction.
Sir, wonderful, sir. It's first time I have heard. I congratulate you for your effort, and you wish you will have many people do it. In fact, you feel so better if it is such a registration is done. Wonderful to hear to you, sir.
Sir, we have Mujabta with a question. Please unmute.
Thank you so much. In fact, I don't have any specific question, but there was a specific query regarding in absence of any nominated person, as there is a law is very clear in absence of any nominated person, if there is no relative or any other side. So it's the duty of the health establishment, mental health establishments, to have the nomination from the social welfare department.
Yes.
And yeah, number second, like I'm very much happy that this is for the first time when a specific program is on the Mental Health Care Act. I'm the lawyer at Institute of Mental Health and Neurosciences, Kashmir. From the last 4 years, I'm working there. So all the things, the finance, the budget, all the things have been very clearly discussed. But I personally feel if we try to find out the immediate gaps and the solutions, it will take us around 75 years to fill the gap. So the best and the immediate possibility for each and every state of India is to have the integration model of the mental health. Now the space of the mental health has been shifted to mental health psychosocial support building, because there are multiple programs of the UNICEF or international organizations where they shift the focus of the mental health to MHPS standard, where we can integrate, because there is a huge gap in terms of the implementation of the law, in terms of the budgeting, as Sir rightly suggested and pointed out. So my point is to have the integrative model of the mental health, to have the integration into the child protection, into the school system and other allied systems. Honored to be the part of this program.
Thank you. Thank you. To have you from all the way from Kashmir. It's really nice.
I see. Now, doctor, can I get some inputs on the decriminalization of the attempt to commit suicide, section 115 or so?
Yes, sir. Yes.
Can you give me some idea about that?
Yes, sir. Government of Karnataka, see, the section 115 says that whatever given in section 309, it presumes that a person who has attempted suicide is having a stress. He has done under a stress, and he should not be punished. Only if it is proved that he has done due to some other reason, like manipulating people, then he can be punished. Only thing what we interpret is it makes section 309 slightly less effective.
Yes, yes.
Yeah, because of the section 115. So
is it regardless of the gender, irrespective of the gender?
Regardless of the gender, mental illness or not.
Okay. Then who has to prove that a mental stress aspect, is it for the prosecution or for the defense?
Yes, sir. I think if somebody accuses, it presumes that he has stress. If it has to be proved that it doesn't have stress, has to be proved by the prosecution.
Prosecution. Oh, I see. Prosecution has to rebut the presumption.
Yes, sir. Yes, sir.
Okay. Okay.
So we have issued a government order in Government of Karnataka that every case has to be registered as MLC, but we have to inquire regarding abatement of suicide, sir. And as far as punishment of home, attempting suicide should be restrained unless it is proven. That's it.
Okay, thank you, Doctor.
Now, if there are, Roshan, would you like to add something more? Baiju sir, the connectivity issue is still pestering him.
Sir, with regard to what respected Ramkumar sir had asked, unfortunately, even in Kerala, there are such instances where people are dumped to the mental health asylums, sir. Even in government mental health center and all, there are a lot of such instances where such people are being dumped. And we are having a person who has completed a half century in the mental health centers. It's a pity, but it's a truth, sir.
I see. In cases where we give the benefit of section 84 of the Indian Penal Code, that he is mentally unsound, and he committed the act while he was unsound, mentally unsound.
Yes.
In such cases, he has to be, he cannot be released immediately. He cannot be set at liberty. The law says that he will have to be detained in some, because he had shown homicidal tendencies. There might be, it may be a murder case. So he might have shown homicidal tendencies. So the law says he shall not be set at liberty, and he has to be kept, and usually we order such persons to be kept in a mental health center until they, and make a reference to the government through the High Court. And it is for the appropriate government to pass orders when a friend or relative comes forward to take care of him without he causing any problem to the society. Are there such cases in the mental health hospitals? And is the government passing such orders for releasing them to a friend or relative who come forward? Or do they really come forward?
Sir,
You can't say that.
I know my experience is most of them are kept in a criminal ward. They have a separate criminal ward in each mental hospitals. It is guarded by police, high security would be there. And before him being released after curing of mental illness, again they have to go to the court, get permission of the concerned justice. Then only he will not be released.
Why? I think there is section 335 or so. Government is given the power. I don't find any. 339. The state government has to do that.
Yes, sir.
There's no reference back to the court. There's no provision for referring the case back to the court. I don't know.
But somehow that is what my knowledge, sir. Usually most of the psychiatrists are not confident enough. They again inform the judge, concerned judge. Then if he's released, then he will be released to the family. That's what happens in some of our psychiatry.
I see. Thank you, Doctor.
That MCI mental condition report is being sent in a periodic interval, and they are retained here in the forensic ward, sir. In all government mental health centers, we are having separate forensic ward wherein such mentally ill housed, sir.
But section 339 of the Code of Criminal Procedure says when such a person is detained and at the disposal of the government, state government has to pass final orders for a friend or relative to keep custody of the person, who, of course, provided he comes forward and executes a bond that he will take care of the person. He will see that he doesn't commit any harm to the, cause any harm to the public, etc.
Okay, sir. In fact, there are some instances of what we see in our central prison. If a person, we have 90 patients inside our Parappanagar prison, sir.
Okay.
Some of the people are kept in the pretext of mental illness. Relatives never come. They are happy without him. Rarely they will request the government to release him. So they just end there only, sir. That is our experience. Unfortunate stigma, discrimination.
No taker, ultimately. Not.
That is a universal phenomenon.
He is an eyesore for the family. He or she. Yes.
If there are no further queries, I think we can go to Prem for the concluding remarks. You'll have to unmute. I think Mustafa, you wanted to add something?
Yeah, what we have seen, not only me, what we have seen at the mental health institutions, the families disown these types of the persons. So for the same, there is a provision that the government is supposed to establish the halfway homes. So wherever there is no taker for the family, it is the responsibility to utilize on the state, so that there must be, because ultimately the jurisprudence of the law has now changed. Law in itself takes care of these mentally ill persons, whether they are the criminals or whether they are into the mental health establishments by virtue of their mental illness. Ultimately, now there are the multiple provisions to have the short stay at the mental health establishments. So there are like exceptional cases where we are supposed to provide the long-term care at the health establishments. Finally, we need to have the reintegration model of these patients. So for the same, we need to talk about the establishment of the halfway home, so that where they can actually reintegrate into the society.
They left the institution but not reached the home, so halfway.
Yes.
Yeah. Sir, Advocate Ramkumar Nambiar sir was raising his hands, sir.
Yeah, sure. Ramkumar sir, please.
Sir, Chandrashekar sir, I just have a doubt. In Kerala, for appointment of a guardian of a mentally ill person, we refer to Rights of Persons with Disabilities Act under Section 14. And the designated authority in Kerala is the subdivisional magistrate. I would like to know who is the designated authority in Karnataka. Is there any notification, or is it the district court itself?
It is, sir, it is a district court only, sir. I think court, not specifically district court. Under Disability Act only. Any guardianship is not there in the Mental Health Act. Right now, any guardian.
Under the Rights of Persons with Disabilities Act, the wording is either the district court or such other designated authority. And here what the Kerala government has done is the designated authority is the subdivisional magistrate. They have notified. In fact, that notification I interfered and I got it passed by a judicial order from the court. So here they've appointed the subdivisional magistrate as a guardian. I was just wondering whether it is the same authority in Karnataka or is it the district court itself?
I'm not very clear about it, sir. I'm not sure, sir. It's happening in the court. That's why I've attended the court. But it was a district court once I attended. About this provision, I have attended the court, but he was a district judge, chief judicial magistrate.
Many of us are not aware of this subdivisional magistrate being designated as the authority, sir. Even in the mental health field, we are not unaware like such an order.
Yeah.
For 17 years, sir, I've been the amicus curiae, the mental health cases.
Is it reported, Mr. Ramkumar?
Which one, sir?
That order of the High Court? High Court's order, is it reported?
It's not reported, it's just a notification, that's all.
No, you said due to the intervention by the High Court, it was ordered, is it not? No.
That's on an IEA filed by me.
Okay, I see.
As the amicus.
I see. Better that order be reported so that such institutions may come to know of it.
Thank you, Justice Samir Ramana, for joining. And in fact, it was a very interesting session and we missed you out on it.
Very sorry. Apologies. Joining late.
Last two webinars also you were absent.
Yes, sir.
There is punishment for that.
Sometimes after lunch on Saturdays, I'm getting some engagements. That's the problem.
I see.
Absolutely. So, sir, as we come to the end of the 277th session, may I request Prem to render the concluding remarks.
That was an erudite lecture. And what Justice Ramkumar asked was whether 309 is decriminalized by way of 115. Actually, there was a case before the Supreme Court. The Supreme Court has sought the central government's opinion whether the central government is going to justify this section 309 again remains or not. I think it's a 3-judge bench by Justice Bobde around 2 years back. I don't know what's the present update in some case called Red Links Confederation or something, which is a public interest litigation. Anyway, it was a very erudite lecture and we have got a lot of learning. Thank you so much.
Thank you, Prem. Arvind Kamal sir, would you like to add something? You like to add?
Thank you so much, sir. Actually, I am from here, Bangalore. I was just trying to, probably try and get in touch with Mr. Chandrashekar for such wonderful thing. And thanks for identifying and telling us that he's here in Bangalore. So it's our pleasure that, we can always go and meet him sometime and probably try and do some difference for these people who are mentally not so well. Sometimes they can also come under the disability, or we can also say that they are differently abled people. So it is not that somebody really wants to do it. Even a healthy person sometimes gets on to one of the statistics with which Chandrashekar sir shared, that 10% of 1.3 crore people can probably are not keeping well, mentally, some or the other way. It's quite a enormous number, and needs to be treated with a lot of empathy, so that these people come back into the mainstream and then contribute into the civilized society, sir. Yeah, thank you so much, and it was so wonderful. Yes.
Thank you very much, Dilip. Dilip sir, would you like to add something before we conclude?
I just logged in, hardly 5 minutes. Hardly 5 minutes.
Why not we think of some friendly organization? Because Section 339 says a government can release such person who is cured after having given the benefit of Section 84. Why not if in the relative will definitely will not come forward to take him? Why not we have an NGO who are friendly with such persons, so that a friend or relative, section says friend or relative. Instead of relative, a friend can be there. There can be a friendly association of who are philanthropic persons can form an association to take care of such persons. Somebody should take the lead.
That is indeed a very novel idea, sir. We are having a lot of NGOs in the psychosocial rehab field. In fact, today we are having a state level workshop here, sir. But this thought has never occurred to any of the NGOs. It's a very...
Section 339 says friend or relative. Relative is definitely not going to come. Then why not an NGO form a friendship association, an association of friends. And as a friend, why not they take care of such persons? Unwanted persons to the family.
In fact, sir, I was quite sorry to interrupt, sir. Sorry.
Please. No problem.
Yes, sir. I was just really wondering that some 90 odd people are there in Parapanagraha who are actually, ill, and then no takers are there. So the question is, at what level have they improved? If they were ready for released, are they going to just like that release them? What if their conviction period is over? Now, these are the questions I had, probably, if possible, I'll try and meet Mr. Chandrashekar in person.
Yes.
And so far as the NGO is concerned, I'll be more than happy to lend my myself here. At least
wonderful.
Yes.
Please go ahead, Mr.
Yes, at least here in Bangalore, whatever possible as a pro bono case, I would like to really, join hands there. And my services, I would like to do it without charging any fees at all for any good noble purpose, sir. Yes.
Excellent.
Wonderful. So, sir, I would say not just a wonderful presentation, but a fruitful presentation also. I mean, something positive has come out, some new ideas, new thoughts, and new friends to this platform. I hope all of you are here to stay, and we'll all take this platform to more constructive and positive things, so that something could be done. Not just deliberating, discussing, but end of the day, we should be able to implement something. We hope we'll be able to do that. So as we come to the end of the 277th session, let us thank the speaker of the day, Dr. Chandrashekar, and the wonderful introducer who rendered the introductory remarks, Dr. Roshan Bijilee sir, and of course, all of you who participated constructively, especially Justice Ramkumar sir, Advocate Ramkumar Nambiar sir, Hari Kumar sir, and Arvind Kamal sir, Justice M.V. Ramana sir.
No, don't mention my name, please.
No, sir.
You are a very prominent and learned member of...
Your presence itself adds charm to our platform. So, it's really nice, so that when persons from different fields, stakeholders from different fields come together, different disciplines come together, sir. End of the day, it's not just confined to advocates alone or just lawmen alone. Let us have this interface of law, technology, medicine, all coming together so that end of the day, we'll be able to do something to the society at large. With this novel and noble thought, let us take say goodbye for the night, and please do take care and stay safe. Till we meet again next week.
Thank you so much.
Thank you very much, sir.
Thank you. Thanks so much.